Hi, I'm Ira Stephen Nathenson. I'm a law professor here at the School of Law. Myself, I teach intellectual property and procedure as well as internet law. I'm really delighted to be here as the moderator for this wonderful panel on contracts and technology. I'd like to introduce our panelists, and then they'll give their presentations, and we'll have an opportunity towards the end for questions and discussion. Immediately to my right, we have Christopher Bisping and Timothy Dodsworth from the University of Warwick in England. Christopher is an assistant professor. He got his LLM in 2000 from the University of Edinburgh. He later served as a researcher at the Max Planck Institute in Hamburg. Worked as a lecturer at the German Academic Exchange Service. Then as a lecturer in law at the University of Leicester? Of Leicester, my Americanism there. And since 2012 has been an assistant professor at University of Warwick. He's a member of the Society of Legal Scholars, European Law Institute, and the fellow at the Higher Education Academy. He writes, as you would guess, in contract, consumer, and commercial law. Along with Christopher is Timothy Dodsworth. He's a PhD student at the University of Warwick. He got his LLB with honors from University of Sheffield in 2006. His LLM also at Sheffield in 2010. And since 2011 has been a Herbert Smith Fellow at the University of Warwick. He's an associate member of the Higher Education Academy, a member of the Society of Legal Scholars, and a member of the British Institute of International and Comparative Law. The other speakers to my left, I have Jeffrey Ritter. Jeffrey is recognized as a pioneer in shaping the rules of online commerce. His career spans work at the ABA, the UN, and a number of highly recognized companies as clients. Now he works at developing and teaching graduate level courses in information governance and cyber law at Johns Hopkins Whitting School of Engineering and at Georgetown University Law Center. And later this year, we'll be publishing his book, Building Digital Trust. I should add, just as a side note, Jeffrey and I also go way back. He and I also worked together at the law firm that's now known as K&L Gates. That would have been at the beginning of my legal career, and I'm really delighted not to just meet everybody in this panel as well as you guys, but also to get the opportunity to reconnect with Jeffrey. To Jeffrey's left, we have Deb Quentel, who's from CALI. She has, for the past 16 years, been CALI's Director of Curriculum Development and Associate Counsel. She's also served as a visiting assistant professor at Chicago-Kent College of Law, executive director of a legal aid organization. She served the Illinois arts community and has been an associate in a Chicago law firm. At CALI, she worked with faculty who write lessons and write E. Langdell case books, and has worked with over 100 professors to oversee the creation of more than 600 CALI's, and I'm sure as many of you know, CALI's excellent lessons. She also works on matters regarding IP, contracts, and other issues. Finally, and let me pull up, since we're doing contracts and technology today, it only seems appropriate that one of our presenters be someone brought to us by the miracles of modern technology. David, you can hear us, right?
Yes, I can hear you.
Excellent. Can you hear me now, I guess I should be asking. David is the author of the ABA's best-selling manual of tech contracts, the Tech Contracts Handbook. He's the founder of Sycamore Legal PC. It's a San Francisco boutique firm focusing on tech, IP, and privacy law. His practice includes tech agreements, privacy, information security compliance, IP counseling, and much more. In his previous life, he worked as a general counsel of a publicly traded software company, a VP of business development for a tech startup, an attorney at Morrison & Forster LLP. He's a Harvard grad with an LLM from Cambridge. And not only does he do all this, but in his spare time, he writes about history for young people using the pen name David Carthage. So I think we're going to have a very interesting panel today, a lot of very interesting discussion. Our first speakers are going to be Christopher and Tim. So I'm going to minimize you, David, and we're going to pull up the PowerPoint. And whenever you guys are ready to go, thank you.
Thank you very much. I should say thank you for the very warm welcome in general here to everybody, for the warm welcome in a very real sense of the word. It's warm. So if I don't make much sense, blame Swiss International Airways. They got us stuck, and so we were rather late. So and I might not be at the full potential of my capacity, so apologies. I should also start by apologizing for, in a way, trashing your panel, because I don't think we're going to talk that much about technology. It's in the title, but it's only one of several aspects. So we are going to mention technology, maybe not quite as much as some of you would have liked us to do, because we also plan to mention a bit of law and a bit of culture and maybe throw in a good measure of economics, but that from somebody who's always stood with the Latin maxim, judex non calculat, judges don't do numbers, okay, so take it with a pinch of salt. What we were interested in are mobile telephone contracts, as we would say, cell phone contracts, I think, on this side of the Atlantic. Because they are, in a way, one of the modern prototypes of long-term contractual relations that consumers enter into. If we forget about leases of land or so for the moment, which are all very highly regulated, have over centuries developed their very specific body of law for that particular area of law. If we want to look at a contract, a normal contract, then probably a mobile phone, cell phone contract would be one of the most important contracts that a natural person, a consumer, might enter into. And then while we looked at that, we, I think, identified three areas which were of pivotal importance for any consumer when they were, in a way, maybe stuck, as you might want to, in a long-term relationship. And that was, first of all, the original length. For what amount of time would the consumer be bound to the contract without getting out? Secondly, can that renew at the expiry of the initial term? And thirdly, then, during the currency of the agreement, while it lasts, can the terms be modified by the mobile phone company? And while we were looking at those three aspects, we then identified four areas which shape mobile phone contracts in general. And there were technology, the ever-changing technology in that area, and we've later on chosen the example of the iPhone as a new technology coming in. We looked at the law, the role of regulators. How do regulators interfere with the market powers and by their regulatory attempts change the content and the design of contracts? We looked at economics. How have markets shaped over time, and how did the markets develop before regulatory intervention? And then, in a way, my little, or both of our little baby, culture up there, because we are convinced that there are unwritten cultural assumptions underpinning this area, probably as many other areas of law, and we haven't quite managed to put our finger at them yet, why that is and what they are exactly. So for all of those aspects, we are looking for your help today, and it is work in progress, and we would very much welcome any feedback that you might have. What we are going to do, I'm going to swap over to Tim now, and then later I'll come back for a bit, and then Tim, so you can choose your favorite. Thank you.
I guess I've lost already. I'm going to start off with if we imagine that what we were showing there with the wheels at the beginning as three parts, as part of a triangle, I'm going to start with the first one, which is the initial commitment period, the time that the consumer is stuck in that contract originally. And we see that as general law in Germany, we've got 24 months. In the UK, it was generally between 12 and 18 months, but now it's moved to 24 months. In the US, I think it's quite normal to be 24-month contracts, and in Canada, we have the situation of it being 36 months, but now being lowered to 24 months. The law behind this is that in Germany, we have generally legislation on unfair terms, which limits any consumer contract to 24 months. In Canada, we have the wireless code, which has limited it to 24 months. We do correct me if I'm wrong here. We don't really know whether there's a legal limit in the US. And we don't think there's a legal limit in the US. The interesting part is what happened in England. In England, well, in Europe, we brought in the directive, which is the Directive 2009-136, which said that the maximum amount of time that a mobile phone contract could be is 24 months. And then we suddenly see that the market changes quite significantly in England, because if we look at the end of 2008, or the beginning of 2008, we see here that the majority of phone contracts in England are still 18-month contracts, with very few actually being 24-month contracts. The moment we bring in the directive, which is around about, or the knowledge of the directive, we see a jump in the amount of 24-month contracts, and then this gradually rises until 18-month contracts almost disappear, with the rise of 1-month contracts in there. Now, there's of course quite a few influences that we see there. Generally, just to set out, in Canada, it's not surprising to see that bringing down the length of the contract increases the minimum price. And we see that in the UK, by maximizing the length, the price of the contract, the monthly price, will go down. But what's also interesting is that we see in England, if we look at the economical side, that prices deviate. So we've got here particularly, and what is very interesting, is that from this time on, and we'll see in the context in a moment of the iPhone coming out as well, how this may have developed, a large rise in the cost, a large rise in the lowering of the cost. So in other words, the cost becomes lower overall, which we just saw. With the length of the contract increasing, the monthly price can go down. Not much of a surprise. We see also, though, and we want to bring this in as a technology part, the part that Christopher promised as being the part of technology here, is the iPhone, which at the end of, here it came out on the 29th of June 2007, slightly later in the UK, which was the end of 2007, and we suddenly see that that also affects the market here with other contracts and 24-month contracts on the rise, but also that people seem to have outright bought the iPhone and then gone for a 1-month contract. So if we look back at the slide beforehand, that's where that increase in the low monthly prices has come from, which explains this figure right here. And also explains, of course, the rise in the 24-month contracts. And this is where I hand back to you on renewal.
Thank you, Tim. About renewal, having looked at the initial commitment period, then the next question is, can the contract just renew for another commitment period? Or does it come to an end unless the consumer does something, does a positive act affirming, I would like to continue with this contract? Or does it turn into a rollover contract which a consumer can terminate by giving mostly a month's notice or so? And we see here that for German, or we should probably say, why have we chosen those legislations? I'm German, Tim grew up in Germany, we both work in England, we are guests in the United States, and Canada was just very topical because they just changed it on a regulatory basis, so there's our selection, not scientific at all. So the German model, or the German law, always is being regarded as very consumer-friendly, is that the consumer has to give notice, and there are very strict periods of time, and if you forget about the date of the renewal and you haven't given your notice at least 6 weeks before that, then bang, you are stuck for another year. The maximum here is another year, also that laid down in the general unfair contract terms legislation. In England, the consumer is asked to give explicit consent to a renewal, and unless the consumer does this positive affirming act, the contract is turned into a rollover contract which has no commitment period anymore, which can be cancelled by giving a month's notice. What we have seen or think to have understood from US law is that it varies by state what exactly the requirements are in long-term contracts, whether they turn into rollover contracts, whether notice must be given, a reminder being sent by the mobile phone provider, or whether the consumer has to actually engage into a positive act. And in Canada, after this wireless code came into force, it is now also, like in England, an explicit consent required, or that 1 month periods, the rollover contract of 1 month. Now, we've wondered ourselves, why is it in England? And it's not only, when I first moved to England 10 years ago, I always had my German habit of putting in my diary when I have to cancel my insurance contracts and everything. But then in England, hey-ho, I always got letters from the insurance company and other people saying, look, your contract is about to expire, you better do something. And I thought, that's so much nicer, isn't it? And we wondered, why is that the case? Why it would be so much easier to take advantage of the lazy consumer who's bound to forget the dates. And the only possible legal reason that we could think about is the statute of frauds, which in Section 4, I think in many US states is still in force, and England has long been given up, but which has always required that contracts that cannot be performed within 1 year have to be evidenced in writing. So, and that therefore, although that's not a big hurdle to overcome, there was a little bit this fear, we better not have it for more than a year, otherwise we get in trouble. But we haven't been able to actually verify this point. It's just a hinge that we've got. So, and this then should also apply to the US and to Canada, where it is actually still in force, that being a reason, but it isn't. We also notice a slight change in the UK market, but here, this is now where we think that some cultural underpinnings come in, and that people have just over a long period of time been trained in a way that contracts are done in such and such a way, without there necessarily being a strict legal reason for it. There is not a strict legal reason why in Germany it has developed in a way that the consumer is required to give notice, whereas in England it hasn't. So I would love to hear about this if anybody can. So far nobody has been able to help us with that. So I've already spoken about Germany. Just that other states, like in France that we looked at earlier also in an earlier research that we did, there we have a reminder model that the operator has to send the consumer letter saying you have to do something. Unless you give notice, the contract will extend. Now, in England, we have had some regulatory intervention by Ofcom, which is the telecoms regulator, and Ofcom has said, look, the renewal for mobile phones is now prohibited. Unless the consumer actually does do a positive act, it cannot be renewed. Why? Because the market had started to change, and the mobile phone companies had tried to automatically renew contracts, but now they cannot do that anymore. Similarly in Canada, and again for the US, our finding has to be, I think, that it varies by state. That brings us to our last point, the question of modification. And often consumers sign up for a 2-year deal thinking, oh, I'm going to pay X amount of money every month, and that is fixed for the duration, but the companies put in a clause allowing them to modify the price during that period of time. Or indeed other clauses of the contract, but the price is probably the most sensitive for the consumer. In Germany, we have a very strict position. It is not allowed unless very strict requirements are met. In England in the past, it was allowed because it was not regarded as a material detriment, at least if it was in line with inflation or other clearly identified costs. Here again, I think it would depend. You see, that's our lazy answer. It depends by state. We are not saying what. And in Canada now, at least under the new wireless code, it would again be only possible, similar to the German position here, that the company may modify the terms, especially the price, if the consumer has given his explicit consent. If we look at it, we seem to notice that in England, lots of emphasis is placed on the procedural steps. So as long as you outline the procedure, how the price is to be determined in the future in your terms of contracting, that's okay if you then stick with it. There's a case on it on a different topic, but which would speak for the same area. The German courts seem to look more at a substantive justice, not so much a procedural justice, but is it fair? Should the consumer be bound by any price increase? The American position seems to point to good faith and place an emphasis on was it done in good faith, which might look similar to the German position, Germany having a very strong culture of good faith, but I think in practice is more akin to the English position by saying, did they meet all the procedural safeguards? Did they actually do it in the way that they said they would do in the agreement? But from a cultural point of view, this seems to be the trade-off in Germany for the automatic renewal. It's so easy to renew the contract Therefore, at least the consumer is protected that the terms cannot change while they are bound to that contract. This then leads us to this last thing, which you can maybe look at easier and say that we, living in England, are very lucky in that we have the cheapest monthly mobile phone contracts, whereas Germans pay 4 times as much almost, and which we think might be due to the fact that German consumers are less likely to run away. So they are tied to the contract. And on the other hand, they already know the operator, we cannot increase the price. So they have to start, all the operators, from a fairly high starting point, because then they are stuck with those contracts. It's up to Tim to say what.
To summarize in 11 seconds. Let me... If we come back to our nice triangle of the initial commitment period, so the time that you're stuck in the contract originally, the modification of the terms, and the renewal, we see that the long-term contracts are generally subject to a lot of influence. And we saw as well some that we can't explain, for example, the culture side. We have seen, though, that in England, the fact that the legislator said contracts are now capped at 24 months has led companies to increase the time of the initial commitment period, so from 18 months to 24 months. And we talked about the cultural underpinnings already, and it also shows all this regulation around mobile phone contracts just shows that mobile phone contracts are really very important. And on that note, I did run over, I'm sorry. Thank you.
Don't feel bad. I didn't set it to explode, make noises.
Yes, they do. All right. Hi, my name's Deb Quentel, and I work for CALI, the Center for Computer-Assisted Legal Instruction. I want to thank Jennifer very much for inviting me to speak. I do a lot of speaking, but usually it's about all the wonders of CALI. So if I fall into that, I'm going to attempt to drag myself here into a more substantive topic. I started with the title of Negotiating Technology Contracts. And then as I started to work on that as a theme the past few weeks, I started thinking, well, what really is negotiating? And don't worry, I'm not going to take the whole presentation word by word. But what is negotiating? And to me, negotiating was the process that when I was an associate at a law firm, we engaged in, which was we were on one side of the conference table and they were on the other, and there was a document, and the conversation usually started with, well, I don't like the word agreement in the first line. And at that point, you were ordering lunch and reserving the conference room for the next day. Because negotiating suggests some sort of adversarial situation. And what we're really doing at CALI with negotiating technology contracts, and the focus of what I'm going to talk about is more than negotiating the internal conversation that I, as CALI's counsel, is actually having of how to make a fair contract that we really are aiming for templates here, to be honest. So we're trying to navigate some sort of template that is going to be fair to faculty and then also navigate a fairness to CALI. So that's kind of the perspective here that I'm coming with. So let me just, for the folks that are new to CALI, what we're about roughly 950 interactive web-based tutorials. We've got these free casebooks out there. We do a podcasting. We have Laudables, which are a 10-minute audio law professor. We have a bunch of websites under our control. We do a conference with recorded sessions. We do a MOOC. I view all of these elements as potential for problems and potential contract situations. So this is kind of the world that I'm trying to contract within. This is how I divide the world. We either own it or we license it. We either keep use of the material exclusive to our members or it's open to the public. So I'm trying to, and there's There's no, it's not better to be on the far right side of the x-axis or anything. It's just you're in one of those quadrants or you're not in my world. So this is where everything fits in my world. Starting over here in our lower left, well, in our lower right quadrant are things that we own. And if it sort of appears as a ghost image on the left side where we're licensing it, it's because the item is very complicated and I have to deal with both licensing parts of it and owning parts of it. So what we own is we own our CALI author software. So that's nice. We can control it completely. And it does actually have some license elements of bits of code that are open access. Then we own our lessons, and we own our time trial cards. And these are our time trial cards. It's a deck of 200 cards, and we sort of own it. I don't own the front. I license this beautiful artwork. I own the back. I don't own the QR code. That we got from somewhere, wherever the QR code store, I suppose. I don't own the part of this that would be considered public domain, but I do own whatever bit of original content we've got. And then if you play the online version, we've got a really cool theme song that goes with it, and we own that. So these are all the contracts that we're trying to sort of juggle out there. And then if you move into our things that we own that we share open to the galaxy, we share Laudables, which is that Walkman podcasting little green icon thing. Laudables we purchase a 10-minute audio from faculty, but when I think about it, we don't really own the whole thing because I've got Creative Commons music as my intro and outro. So that's kind of a part there. Our A to J author we co-own with Chicago-Kent, Illinois Institute of Technology, Chicago-Kent College of Law, Center for Access to Justice. Elang Dell, we purchase the materials from the faculty members who write the case books, and then we slap a Creative Commons license on it. But as you can see, we don't own everything because faculty members like to reference a New York Times article or the restatements or something that somebody else owns. So we have to license that. And I'll get more into that because that's where my life becomes extremely stressful. And then we own a growing number of beautiful drawings, about 480. And these are the only things that aren't on our website. So I like to say, what would the cows say? And they would be living out on the Flickr website, actually. So if you want to go and use some really cool images, I was talking with someone at lunch that said they like to use images, but it's so hard to find Creative Commons things. So we're releasing those Creative Commons. All right, so back to our world. So we own a lot of stuff. We release a lot of stuff open, and then they're these little nuggets of chaos, as I lovingly think of them, that are inside of our products that are licensed. And licensing so that you can give it broadly to the world is a real bizarre experience. Because when you go to somebody to license something, their first question is, who has access, how many people, and what will you be charging? And my response is, we're giving it away for free, and it's on an open website. So they then look at a general census of the entire world and say, so approximately 400 billion people will be looking at this. Great. We'll charge you $1 per use. That sounds fair. And I'm like, no, let's take out all countries that have poor internet connection. Let's take all countries that don't speak English, and let's just knock it down because we're a 501c3. And eventually we sort of find, in most cases, some number, or we go elsewhere. So it's people really freak out when you're going to just open their material out to the world. Our conference logo, which is that flaming tire of love there, that is just a big ball of chaos in my mind. We don't own any of the presentations. but everyone by presenting agrees to let us put things out there on the website. And then that's probably got stuff inside those presentations even that is an onion layer of copyright. So there's a lot of things that are complicated about our materials. So basically, what I think about when I'm doing my internal thoughts of what should we try and have a template contract, or what are we trying to get in a license, these are the basics that I'm aiming for. Our goal would be to have contracts be 2 pages. I really can barely say that with a straight face. I have a lot of trouble going for under 2 pages, no matter how small I make the font. There just seems to be things that you want there so that I can sleep just a few hours uninterrupted at night. I do want to be fair. We want to be fair both for CALI as a fiduciary relationship to all of our members, and then also fair for our authors. I'm building long-term relationships with all of our authors. This isn't like I'm buying a car, and this year I'm going to buy a Kia, and I don't care if I make the salesman despise me, because in 5 years I'm going to go buy a Camry. I have to ride in elevators with people at AALS. I have to engage in conversations with faculty who are our members. So we're very concerned with being fair. And so part of being fair is we look at the types of contracts that we have at CALI. And some we have with individuals for a service. We contract with somebody to write some bit of web magic for us. Some is with licenses. We have a license with American Law Institute to use restatements inside of our materials. And then some things are just, we're a business, so we have contractual relationships as part of our website, end user license agreements, terms of service, things like that. And I break out the categories there, and then I say, what is my relationship with each of those entities? Is it long-term? How many faculty am I dealing with? We want to treat everyone the same, which often means everybody's going to get paid the same amount of money. We work with independent contractors, which makes life interesting. And then I've got this category of vendor entities, which would be more of a business than an independent contractor person. So licensing, as I said, is a problem. It often limits the use of materials. I do not like licensing. I would like people to give us stuff because I have some material that, because I have a beautiful box of material and it's got one little component in it that is licensed, when that piece of licensed cheese expires, the whole thing is tainted. It's the one apple spoiling the bunch sort of thing. Sometimes I have no alternative and I must license something. And then it requires me to keep track of it, which in our volume of growing lessons and my petite size of one-person law office at CALI, it's just really hard to keep track of these things. I like Creative Commons licenses, and it's one of the reasons that we own things so we can release things on a Creative Commons license. So when I'm dealing with contracts, I think very much about what the content is, what are we getting from the people, what are they really going to deliver, and this is the hardest component actually to draft in the contracts, because often we're not really sure what we're going to get until the magic appears, because we're hiring the person for their independent contractor brilliance. And so that's kind of tricky to define. I'm real big on grabbing the copyright and purchasing the copyright from everyone so that I can turn around and put a Creative Commons license on it. I fall in the camp of spouses must also assign copyright over to me because for community property states, I don't want to become the teeny little negotiating tool for something in what would it be when divorce? I was losing the word. And then disclaimers and warranties and indemnification. Well, that could be about 4 hours right there, but I did promise 2 hours in exchange for an appetizer to my colleague here, or 2 minutes rather. So I worry very much about disclaimers, what you can disclaim, in the current world, and I worry about our liability. We're a very small entity. We don't have a lot of budget for that. So this is where we contract for people. We have people buying lessons or making lessons for us that we then purchase. We have authors writing E. Langdell casebooks. Casebooks are the only area where I actually negotiate a price for the book. And I have a checklist that I walk through. It's 18-point checklist in terms of what are factors that I consider in evaluating the value of a casebook. When we record laudables with faculty, we purchase those. I purchase peer reviews of chapters. I have small contracts, or sometimes it's just an email that goes back and forth that says, you're going to do this, and I'm going to give you this in exchange. Aren't we all happy? And that is pretty much our world of CALI contracts. Thank you.
Well, we've got to start this off with a little bit of different topic. I want to talk about cufflinks and fashion. So these cufflinks that I'm wearing today are very distinctive. If you look at them here, you see that they are microchips dated 1982, Intel, gold, 14 karat. I bought them in a market a few weeks ago when a lady was selling jewelry made out of discarded motherboards. And I told her that I was a really geeky type lawyer, and she said, have I got something for you? What's really cool about these is that they gave me a reason to get away from a really dull topic called the loss of reason to compliance. Instead, I wanted to talk to you about dragons. You remember that spot on a map that says, here there be dragons? The original map makers put that on the map because the sailors that came back to port that they interviewed over drought and beer and other whiskeys to find out what was out there couldn't remember where they had been, or would not admit where they had been. And so rather than showing their maps to be defective, the map makers would say there were dragons. Because that was where the unknown was. That was where, if you drifted, you would certainly have oblivion and chaos and death. Well, beginning in 1982, time and time again, my clients seduced me to go beyond the horizon to find and slay the dragons. We started with the legal value of faxes in China for purchase orders. And then it was electronic data interchange, and this newfangled thing called the Internet, the World Wide Web, the semantic web, XBRL, information security, mobile data computing. Every time they dragged me across the horizon where there be dragons, we found out there were no dragons, there were solutions. There were ways of carving the rule of law into the net, and it was the contract that was our weapon. But in 2006, I saw another horizon, a horizon that I was convinced the dragons were real, the horizon which was so unsettling that I walked away from our profession. And for the last 7 years, I have worked to find out whether that horizon was real and whether the dragons, which were threatening the competency of our profession, were real. This afternoon is the first time in 7 years of research and writing that I've had a chance to share the results of my adventure beyond the horizon in the last 14 minutes we have. What technology does is it takes us to a place we've not been. Sailors, as they left the horizon, always had rules about how to sail and where to go. But each time technology innovates, it takes us somewhere place. There are no rules. Ellen Kirsch, the original general counsel of AOL, said, the cool thing about my job is I get to make up the rules every day. But something was happening in 2006. Lawyers were no longer central to the development, and we were even less relevant to the execution of the rule of law. clients, industry, the investment momentum behind all of the technologies that wire us together as a world today simply were pushing us aside. There was a time back in the last century when I began practicing law, when the lawyers were the men that brought the team to the table. The lawyers had the understanding of the deal, the law, the rules, the games, how to win, how to negotiate, how to settle. But over the last 30 years, it turned out that the lawyers were no longer playing that role. Friday at 4 o'clock, they would get the knock on their door. Hey, we're going to release an entire new $5 million product on Monday. Do you have any concerns? The British Standards Institute was so frustrated with the legal profession and their dealings with digital information, they have published their own rules on the admissibility and weight of electronic information as evidence. And not a single barrister was involved in the crafting of those rules, and they are now being finalized at the ISO as a global standard, making America's antiquated hearsay concepts simply that, antiquated and unconnected. What has happened is that we as a profession are no longer leading commerce in setting the rules. Technologists and the technology itself are doing so. And so trained by security professionals to look for the root cause, I've determined what it is. Simply, it is our failure to be competent in authoring the rules of engagement for this digital world. The only way you fix a root cause is to undertake to call it out for what it is, a failure, and to move on. To find our way, to keep this profession and contracting relevant, we have to find a way of expressing and developing the competency to lead. Now, here's a great example of what the world looks like today, and we saw some in other programs. This is vocabulary out of a HIPAA model agreement for protecting health information. See some words up there: as necessary, if necessary, proper, appropriate, where applicable, promptly, material, appropriate, reasonable. All of these words of vocabulary that have ambiguity are fundamentally at odds with a global communication grid that requires precision to execute. Binary, 1 or 0, yes or no. There is no room for this vocabulary. This wording, this vocabulary, actually represents something more. It's an invitation to our clients to do the one thing that is inconsistent with every investment that is made in the net, and that is that we are telling them that they have to guess what's going to be appropriate. They have to guess what will be reasonable. And no business wired to measure performance at a Six Sigma level of 1 in a million wants to guess anymore. It just doesn't work. In my classes at Georgetown and Oxford and Johns Hopkins, I use the same thing. I say that what we are suffering from is the plague of Siam. You remember that Broadway show, Little Shop of Horrors, with Seymour? It takes a little plant and it turns into a big monster that eats up, named Audrey. Well, Audrey is our own vocabulary of drafting contracts that's consuming us. The plague of Siam is semantically intentional, ambiguous meaning. When we introduce the words that we think are giving our clients flexibility and the chance to advocate when things go up in smoke, we're actually destroying the investment they're making in the communication efficiencies and data certainty that allows them to make money. And so this plague of Siam is what's killing us. It's why our clients don't want to talk to us. The two words they always hear that destroy our value to their investment are what we always say: it depends. Where we're sitting as a profession is at the dilemma of dead man's curve. A lot of you don't remember the song from the 60s of Jan and Dean. Look out, look out, look out, look out, you're going to die. But that was the song of dead man's curve. This is the old Ridge Road. This was the dead man's curve. And cars got faster, and they rolled off the edge, and they died. So they had to put rocks as a border to remind you if your wheels hit the rocks, you're going to die. They still did. They went faster. And then they said, well, we'll put up wooden barriers. And the kids got faster and broke through the wooden barriers, and they died. The problem was what we were doing is we were patching. We were fixing by remediation. And whenever we're fixing infrastructure by patching, it invites and challenges people to go beyond. and prove the patch doesn't work. And we're still patching with contract language. We're still patching when we're allowing the plague of Siam to persist. What happened in California is they abandoned the old Ridge Road. And they said we reached a point that the infrastructure no longer works, and we have to allow velocity. We have to allow momentum. We have to allow growth. The same values that have driven the global digital space that is now the basis on which the world works. And so I suggest that it is time to abandon the plague of Siam. It's got us. It's just like any other plague that in Europe and in England back in that time. It's killed a bunch, and it's going to keep killing a bunch of lawyers unless we change. And so I was delighted to hear Kingsley's presentation at lunch today because he called for the same thing that I suggest. We are entering an age of quantitative law where compliance with rules is objectively measured, not judged. It's not such a radical concept. Speed limit's 25 miles an hour. EPA emissions are 35 particulates per million. Time and again, we're now seeing the execution of formal law measured by the machines. Why are we still writing laws that suffer from the plague of Siam? We have to do it differently. I was intrigued by this set of slides which show that screenshots from a records management program that was actually being commercially used. It's now been acquired by HP. But look at the detail that they're doing just to track records, right? Up here on the right is the audit log. And you see here all the things that are check marked. No, you can't see because of this particular screen, but there's also 35 other events the system's auto-logging. This database at the bottom is every single touch by every single person on every single keystroke that affects that record. And yet we still have rules plagued by Siam that say the company shall maintain reasonably appropriate records management procedures. Baloney. That is quantitative law. To succeed, we have to design and deploy methods of authoring our rules that enable the rule of law to be integrated, aligned, and enable all things digital to be part of a social culture that advances on the principles of the rule of law, which is that we not conduct war to acquire and protect assets. So, where do we go? How do we go? Well, I went back and looked at some of those battle journals, you know, the ones carved on papyrus from the late 1980s and 1990s that I wrote about how did we win? How did we deal with those dragons? Here was one of the first inkling. In 1990, Professor Amy Bloss, who's in the audience, led a working group to create something that at the time seemed phenomenal, the ability to form contracts without paper. The most recent study shows over $800 billion a year globally is being done by electronic commerce, growing by 30% a year. But it began with this simple illustration, that we said to make a contract legal, we had to agree on the technology rules, the standards, the document formats. And slowly we began to understand that to have a binding contract, we had to have functioning technology. That grew to service-level agreements, outsourcing agreements, cloud agreements, term of service. All of these now, where the legal piece is 15 pages, the technical piece, the rules of engagement, may be 100 or 125 pages. We're incorporating international standards of dozens of pages. The net result of this is that the law has to be connected to the infrastructure or we will fail. But let me show you what else I've discovered. In Singapore, the Building and Construction Authority now has connected every single bolt, shim, door frame, fire extinguisher, and electrical plug into a rule base. All the building code is automated, so that as the architect builds the building on the screen, all of the rules are being conformed. You can't submit a design to the Building and Construction Authority unless the software says the rules have been satisfied. The result, they went from 45% approval to 94% approval on initial drawings, Building construction accelerated by 27%. Everybody's making money. The buildings are safer against the earthquakes that tend to plague Singapore. They're executing rule-based design. On the architect side, here's some screenshots to show how I just want to build a building with walls and roofs and frames. But as each component is being added, each element, notice on the far right a column called rules, and they're linked. And the software is taking the rules and connecting them to the attributes so as the building is built, they can assure by design that the rule of law is being fulfilled. Fascinating. Economically stimulating to the industry. Everything works. Are we doing that in the law? Here's a screenshot of a SEC filing where every data character has been tagged so that its meaning is precise, absolute, not capable of lawyers arguing after the fact of millions of dollars of investor fraud. Oh, we tried to be making a reasonable disclosure. We really meant that to be a disclosure of his stock. Everything is being tagged and indexed. Meaning is precise. And as a consequence of that, we are seeing all of the vocabulary of SIAM erode away. We are simply not relevant as a profession to the execution, the precision, and the return on investment that the technology demands. We have to change. The single biggest obstacle, like the architect who has to assemble all of the electrical and plumbing and land use and weight load rules, is getting all the rules together. You can't just find them on a single piece of paper. You can't find them in just one book. We have to accomplish this by not only dealing with our technology, our legal rules, but there's all these other rules that we've never been trained in, we don't have exposure to, we don't know they're there, and yet those are the controlling structure for how our clients are designing systems, relationships, execution, commerce. And so I've built something that's I'm excited to share with you called the Unified Rules Model. It's a way of bringing together into one structure, in the same way that the architects do in Singapore, the rules by which we execute commercial relationships. It has 3 layers: a public layer, an implementation layer, and an execution layer. Now, time is brief. The public layer is what we know: statutes, regulations, courts and agencies interpreting them. And then there's some principles like the duty of due care that's not in any statute, but certainly is part of our legal framework, and interpretations there. That's law. That's what we think of as law. But as lawyers, and the Kingsley's work is so exciting to see being done, at the implementation layer, this is where we do our work as lawyers. We have to create work product that navigates the public layer. We have to author business rules and contracts, policies, procedures, and protocols. We have to write technology rules, all of the things we don't learn in law school. Well, except perhaps in my classes, where our students have to read ISO standards the same way they read statutes and cases, and they have to be able to produce work product that integrates the two. Those also have interpretations, but the layer that we don't do, the layer we don't connect to, is the execution layer. This is where there is no discretion. This is the job you do for human resources. This is what technology must fire as ones and zeros. This is the process that must get us from A to Z. This is the rules that govern the digital information assets that are the new wealth. Bitcoin is just a small drop in the bucket. Personal information is a small drop into the bucket in the economic wealth that is represented by digital information that is governed. And that's what our clients want. This thing, this unified rule model, is going to allow us to do different things. But one of the things that's most exciting is it gives us a structure in which we can see the path forward, and not merely a horizon populated by dragons, of how do we progressively automate into the technology the rules by which we live. It's inevitable. We will do this. It is how we create wealth, is by reducing the inefficiency of human discretion where people don't do what we tell them to do. They do use the word password. They do put their dog's name on a sticky underneath their mouse pad, and they do far worse. Every time I make money with technology, I'm eliminating the discretion of human beings to not do what they are told. And when I look at the portfolio of commercial agreements by which we run our world today, they are antiquated tools that are no longer consistent with commerce. The URM requires and enables something that we must adopt, as do our clients, as does the net. Semantic precision. Ambiguity disappears, precision gains, and the net result is that we connect the rule of law to technology. We regain our professional role. Allow me only to say this seems like an impossible thing, but as Kingsley wisely said in his luncheon address, he's a guy that does the doable. So I couldn't figure this out if I couldn't try to see if it worked. Over the last 4 years, we took the hardest body of information in the law, case law, where it's not standardized by statute, but every judge says it depends. And I said, can we take case law and build it into a unified rule model? And the result of that was a set of portfolio tools of over 120 tools that we built for managing information as evidence in litigation that was mapped, deconstructed, and aligned to controlled processes for over 120 tools lawyers do every day. We talk about non-conforming variation between commerce and contracts. What we were able to do was to build an entire library in which over 2,000 cases were mapped into discipline process, aligned to information assets, and giving the lawyers and their clients confidence that the process was defensible and it was in alignment with the law. One of the neatest things that we built in our effort to be doable was an interview tool where not only were the questions pre-populated so the lawyers had a path forward to go beyond that horizon where most lawyers of the 20th century fear to tread, the horizons that are defined by the digital age. And we were able to show that each question was tied not only to rule authority, but to the case decisions, so that not only did you have a template, a game plan, a structure, an architecture for asking the right questions, but you knew why. And that's what we talked about at lunch. How can we draft a contract for the sentence in it that we cannot show the why and connect it? For 15 years, I was taught how to practice commercial law, and never once was I told how to write a contract so that I made sure that I was advancing the rule of law. The time has come to change. Qualitative law is dead. We are not going to succeed continuing to say that our clients are allowed to guess. They don't want to guess. Quantitative law, the unified rules model, the rules for composing rules that is in the essay that will be in the journal. This really cool thing that I don't have time to talk about called the trust prism, which is a architectural three-dimensional rendering that you can twist to see the system's rules aligned to its assets. All of these are designed to position the lawyer to once again play the role of competent leader as the architect of the systems, the relationships, the markets, and the commerce that drives human society. That's the essential infrastructure. We must connect our rules to the velocity that the digital age requires. In my classrooms, we have eradicated the plague of Siam. As teachers of the next generation, I invite you to join me in that. You're going to find that we have a responsibility to get them over the horizon. And if we do it right, we will discover that there are dragons that are there are nothing more than the figments of our own imagination, and the world will change. Thank you for your attention.
Okay, last we have up David Tollen. Maximize you so everybody can see you.
Thank you.
the iPad?
I can't see the iPad.
All right, whenever you're ready to go.
Okay, thanks. So I'm here today to talk about cloud computing, and the subtitle is New, What's Old, and What's Cool. And what I thought I would tell you about is one of the topics that I am most often asked to address in the speaking I do. I do a lot of training for attorneys and contract managers and others who do technology contracts. And the question that seems to come up most often is, what's the deal with cloud computing contracts? And what they're really asking is my old software licensing toolkit still good? I think a lot of attorneys who learned software licensing back before the first decade of this century learned some basic skills and then became concerned with the rise of cloud computing, whether those skills and that knowledge still applies. And so one of the most helpful things I've found that I can do is talk about the ways in which cloud computing requires new stuff and then the ways in which it doesn't. So what I'm going to do is give you a brief discussion of 4 different clauses that are changed, 4 differences in the way cloud computing contracts work from the old days of software licenses. And just so you know, a lot of the information that I'm providing you can get after this talk still in my book. Nathan mentioned my book. I'll hold it off. It's the Tech Contracts Handbook from the American Bar Association. Incidentally, used by many professors in their classes on technology contracts. But also the book has a website which has a lot of free resources. The website is techcontracts.com, techcontracts.com. And there you can find some of the language I'm going to talk about, free downloadable contract language. So what is different in the world of cloud computing? How has the old software licensing toolkit been challenged by what we're doing? One of the things that I find most helpful in addressing this topic is to start by kind of demystifying what we're talking about, what cloud computing really is, and particularly from a legal point of view. So a couple definitions I think are helpful. First of all, let's talk about what software licensing is. What is a software license? In a software license, you probably know the holder of a copyright, the copyright in the software, grants one of the monopoly rights that the law gives it to the other party. So there's an extension of the right to reproduce, distribute, publicly perform, publicly display, whatever it might be. Those are monopoly rights held by one party, granted to the other. It's necessary to do that because the licensor is giving the licensee the right to do a fundamental thing addressed by the copyright statute, and that's make copies. In cloud computing, you don't do that. The systems that are provided via the cloud don't involve making copies. So what's the definition of cloud computing? Let's talk about that. I put it this way. You can debate a lot what the definition is, but cloud computing is in essence the use of computers hosted elsewhere. Computers hosted in the cloud. This is actually not anything new. It's just something, computers hosted elsewhere have been part of how the technology world has operated for many decades. But the technology's gotten more sophisticated and more effective in the last 10, 15 years, and so you see the rise of a lot more cloud computing. Software as a service, by the way, is just a flavor of cloud computing. It's a particular software application hosted elsewhere. So, okay, back to the clause of the contract. If you've got a software license, you need a grant of those monopoly rights. The core of a software license is the grant of that right to reproduce, maybe distribute, maybe modify. Publicly perform and publicly display don't fit the model that well. They're really there for plays and sculptures and things like that. But there's some logic to using them, particularly for internet-based software. In cloud computing, despite the fact that many cloud computing vendors do this, you don't need a license. This is not an activity of granting rights to reproduce the software. In fact, in a cloud computing arrangement, like say Amazon EC2 or Salesforce.com, the technology that's being used stays with the vendor. The vendor runs it on their computers and the customer accesses it. So it is actually a mistake to grant an intellectual property license in a cloud computing agreement. The core clause, the transactional clause of that deal is a subscription. It's like a magazine subscription. During the term of this agreement, you can use our stuff. That's it. And in fact, if you're representing the vendor or teaching people who are going to be representing the vendor, it's probably not a good idea to grant an intellectual property license, because the last thing the cloud vendor or software as a service vendor wants to do is give its customers rights to its technology, rights to its intellectual property. So a software license is a grant of intellectual property rights. A cloud computing agreement has no such grant, at least usually no such grant. There might be some kind of installed software that you need in order to use the cloud-based system, and then you might get a license to that software, but that's a side issue. The fundamental clause is a subscription. So this difference between cloud contracts and software licenses has an implication for other clauses. There's usually no maintenance clause in a software as a service or other cloud computing agreement. Maintenance is where the vendor promises to come to the customer site and fix things that are wrong or provide updates and upgrades. But if the system is hosted by the vendor, it's able to fix things itself. It's all done automatically. Maintenance is generally handled by a software license, a service level agreement. So the maintenance clause is non-existent or different. Updates and upgrades are non-existent. The system is generally updated by the vendor automatically. The core terms about keeping the service running is the service level agreement, which we'll talk about in a minute. There's also a new core issue that you have when it's the vendor hosting the system, and that is data management and security. And that we'll talk about next. We have a whole new issue with data security. So this is a new set of tools that need to go into that software licensing toolkit. With most traditional software licensing, the vendor provides the software and the customer uses it, and the customer's data goes in the software, and the vendor doesn't have access or much access to the data. Maybe the vendor comes and does on-site maintenance and gets a little bit of access, but basically the customer's got the data. With cloud computing, it's reversed. All the data sits on the vendor's computers. So you need some kind of clause to protect the data, and this has become an area of tremendous amount of work, and a tremendous amount of attention goes into negotiating these data clauses. One of the main messages I have here for you and for those you may teach in the future is don't use a non-disclosure agreement for data security. This is widely done, and it's a mistake. An NDA is an old creature. NDAs have been around for a long time, and they were developed for trade secrets, and they work really well for trade secrets, not for electronic data, particularly not for private information, which is what you're most worried about with your data. The core obligation of a non-disclosure agreement is don't intentionally disclose it. The core obligation of a data security clause isn't don't intentionally disclose. That's almost assumed in some cases. It's you're going to do all these things to protect the data. All this stuff is going to keep the data secure. That's the core of a data security clause. There are very different things. In fact, an NDA usually talks about security of the data almost as an afterthought. There's a clause you've probably seen that says something like, exercise reasonable precautions consistent with what you do to protect your own data of like nature, something along those lines. That's where the whole clause in the data security clause is about that. Also, NDAs usually have a duration. They end. Private data needs to stay protected forever. NDA might end in 3 years or 5 years. Privacy, data protection should continue as long as the vendor holds the data. So what is a data security clause if it's not an NDA? First of all, if you'd like to see an example, again, you can go to the website for my book, techcontracts.com, and there's a free example of the data security clause you can download. Data security clauses talk about a lot of different things. One is data management, restrictions on what the vendor's going to do with the data. The other is data security, and that's usually the biggest part of the data security clause. Procedures about securing the data, guidelines on encryption and compliance with regulations, HIPAA, Gramm-Leach, Bliley, whatever it might be. Usually there's a compliance with law and privacy policies clause too, and then there's testing, audits, and leaks language. This is language about the customer getting rights to test the data security of the vendor systems, sometimes requirements of things like SSAE 16 audits, security audits, etc. All that goes into a data security clause and doesn't go into a non-disclosure agreement. So that's data security. The flip side of data security being such a big deal is our next issue, which is topic 3, indemnities about data security and privacy. When you get the vendor holding the customer's data, you get both parties starting to worry about what happens if the data leaks. And so a new indemnity has joined the traditional intellectual property rights indemnity that vendors used to give, and that's a data security indemnity. And it's a data security it's an indemnity where one party or the other is promising to defend lawsuits by injured consumers if the data leaks. Now, you might think that it's automatically the vendor that is providing this indemnity to the customer, but it actually isn't. I have cloud computing clients that require an indemnity from their customers. They require that the customer indemnify them for leaks, regardless of who's at fault. And the vendor's view there is, well, we're providing a service that involves assisting you with your data. We're not going to look into your data and determine whether we're willing to bear the risk. We're not going to check and make sure you don't have 5,000 children's names and addresses. We're not going to check and make sure you don't have nuclear secrets. We're not going to check and make sure you don't have 100,000 social security numbers in your database. We're just going to hold your data and manage it. As a result, we can't be sure that you're not presenting a tremendous risk to us, and so we're going to ask you to indemnify us if there's a leak. And that is usually where the vendor isn't all about security. The vendor's saying you're taking a certain risk in going with us, and so are we, frankly. We charge you more if we had to protect you. We need you to protect us. Sometimes you do, though, see the vendor indemnifying the customer. That happens where the vendor's whole ethos is data protection, where they are all about being a vault. And then you're more likely to get an indemnity from the vendor protecting the customer for leaks. But anyway, you're likely to see this new form of indemnity in technology-related agreements more and more. It's a subject of a lot of angst and a lot of battles. Final topic, service level agreements and technical specifications. So I think that the heart of an information technology agreement has always been the technical specifications, has always been the language that lawyers usually don't write, that talks about what the system is going to do. And that has not changed with the cloud. Something has changed, but that hasn't changed. We as lawyers don't like to write those clauses. Technical jargon is really confusing. It's not our area of expertise, etc. We just want to stay away from it. And one of the things I'd like to tell you is that that's a bad idea. Lawyers should be trained to work on technical specifications. It's not necessarily going to be, you're not necessarily going to draft the first draft. That's not really our job. It's usually going to be the technical team that drafts that. But you might write the best warranty clause possible. You know, if you're representing the customer and the vendor is promising that if there's any malfunction in the system, it'll give its firstborn to the customer. You've written a great warranty clause. But what does malfunction in the system mean? What you really should be saying is that the system will perform according to its technical specifications. That's the warranty. And if you haven't done a good job of drafting the specifications and making them clear, then the warranty itself isn't good. You don't know when the system is failed. So in the world of cloud computing, you add to or sometimes supplement those technical specifications with the service level agreement. The service level agreement is like a negative version of technical specifications. It's kind of the same thing. It's not a separate agreement, by the way. It's the part of the contract that says the service will perform up to this sort of minimum level. And usually it says if it doesn't, you'll get some credit. The customer will get some money back on its next bill. So the service will have a latency that's better than such and such, or it will process transactions, X number of transactions faster than such and such. All these kinds of metrics, and they vary from service to service, go into the service level agreement. And again, it's kind of the flip side of the technical specifications, where you say, technical specifications, you say the service will do this. Service level agreement, you're really saying the service won't do this. And you can have both in a single document, or you can, sometimes vendors just cite their user manual as their technical specifications and also give a service level agreement. Anyway, in the world of the cloud, you get service level agreements as one of the core clauses that tells you how the system should work. It's a place where lawyers are very hesitant to put their time and energy, but my message to you about that is you should. Make sure that they're clear, make sure that terms that you can't find in the dictionary are defined, maybe if you can find them in the dictionary. Remember that there's no such thing as technicalese any more than there's any such thing as legalese. It's all English, it all can be defined and clarified. So service level agreement, vital. Just a few seconds left. Just want on service level agreements, indemnity, all of those clauses that you find in technology agreements in Word, you can download them and use them. Thank you.
I'm glad to see, speaking of tech, that the tech worked flawlessly. Although I could ask some questions to the panel, I really first, in the time we have left, give you folks the opportunity to pose any questions that you might have to the panel. Anybody? Okay, well then I'll take a shot at it. David, if I put the camera right here, are you able to see the panel okay?
Most of you, I can see the exit sign on the door. There we go. Now I can
We're good? All right.
Hi, everybody.
I do.
Okay. When I moderate, I always want to try to find common threads that run through all the presentations and try to give an opportunity for some shared discussion of common threads. And when listening to Chris and Tim, a lot of what you were saying reminded me of the work of Larry Lessig, who talks about the interplay of law, social norms, markets, and code. Here I suppose we'd say technology as a regulator. And I heard strands of that running through all your presentations, so I thought I would just pose variations of the same question to each of you. I'll throw all those questions out now, and then if each of you could take just a couple minutes to maybe share some of your thoughts in response. I hope these are useful questions. Christopher and Tim, regarding social norms and culture, it seems like one of the things you're very concerned with is the extent to which social norms in various countries may be affecting the private law ordering done through contracts. I think that that's an extremely good topic worthy of exploration, and I was wondering to the extent that you might throw into that the role of technology in each of those countries. For example, do some of the countries use different protocols for cell phones? The U.S., we have Verizon has one standard, other companies have another standard. Might that also be shaping what's going on? Similarly, the life cycle of cell phone technology. We have the tech from the companies themselves that make the phones. Is that life cycle geared towards social norms or markets or anything like that? Deborah, just as Chris and Tim were talking about the relationships of the companies to customers, I heard that same theme in your presentation. Relationships, and I suppose the relationship that seemed to be of paramount concern to you and CALI was your relationship with professors, who are the primary suppliers of your core IP. And of course, as we all know, professors have norms regarding production of content and distribution of content, which are quite different from those embodied within copyright law. So I was wondering about your work to have the social norms of your stakeholders trump existing copyright law. Jeffrey, I heard you to be talking about the reality that code is supplanting law. For example, you talked about the public layer, but now you want to use rules. You want to use code that would quantify rules so that you could have more seamless transactions. And my question to you would be, to the extent that code can be, and in fact, as you pointed out, is used as a way of rule implementation, to what extent would a quantified approach to using rules have difficulties capturing not quantifications, but rather qualitative concerns, like reasonableness, vague terms used in contracts, and legal standards as opposed to legal rules. Finally, Dave, I was fascinated by your discussion of cloud computing, and I'll focus for present purposes on your observations regarding technical specifications. It sounds to me as if one way of putting what you're saying is that code and technology is something that is poorly reflected by lawyers in the private ordering of contracts. So I'm wondering if bad lawyering and bad contracts lead in turn to a bad code. In other words, to what extent is cloud computing changed for the better, for the worse, due to law, due to contracts and other forms of law? And with that, just throw that out for some discussion to the panel. Whoever would like to go first.
All right, well, I'll jump in, not being shy. First of all, I think Larry's original, beautiful, elegant framing of West Coast code and East Coast code set the stage for a debate. He said they're all code. And in doing so, introduced the possibility that it really doesn't matter whether it's in the machine or on a contract. It's going to be connected to measuring performance and discipline, control, and governance. But I actually think that when we dig into the analysis more deeply, none of the words that we associate with qualitative values, reasonableness, foreseeable, are themselves magic. If I ask someone, was it a reasonable inquiry? What I'm really asking are, under these circumstances, based on prior precedent, what rules were needed to be executed to appropriately capture the facts and circumstances that would institute the collection of the information required in the litigation? That's a rule-based analysis. And what we can do now with the machines is simply capture that experience, replicate it, whether it's playing a computer game of chess or whether it's replicating machine trading. The bigger issue I have is that we have to, as a legal community on a global basis, jump ahead. Somebody hacked into the AP Twitter account, said the White House had been bombed, the president had been injured. Within 90 seconds, automated trading programs relied on that. They trusted the information. And $126 billion in trading occurred within 90 seconds. $126 billion, because someone didn't write a rule about wanting to cross-verify Twitters of that level. So, we're figuring it out there. And if I have an advocacy, it's those words disappear from the contracts, but it'll be in the generation of our law students, not in my career. Thank you.
Sorry. No, please. I think that the discussion might either be had at a technological level or at the level of what is a rule, what is a norm, what constitutes it. And there what we have called cultural assumptions probably might be regarded as social norms. If every member of a certain society somehow believes in their truth. Those norms, to put it on your rule-based model, I think would never be able to be phrased in such a way, probably because people just don't have so mathematical brains. I think. With my civilian hat on, legal history change in the civil law, we've always been warned of the bad example of the Prussian land law, the general Prussian land law from 1791, where Frederick the Great tried to put up a rule for every situation and no general clauses in there. So, and it heavily failed. And again, if I put on my comparative hat, I say, well, our civil law contracts are much shorter than those Anglo-American contracts because we don't have to define every single word. We just rely on beautiful general clauses, and then we have cleverly trained people called judges to interpret that.
But you also impose the cost of the lawsuit onto the losing party, which is one of the best restraints on that.
There are again lots of things that influence that detail, and I'm not saying that's a better approach.
Right.
All I'm saying is I think that there are great, again, maybe cultural differences here at play, and that the Anglo-American tradition might lend itself easier to your rule-based approach than the civil law tradition, and some, especially places that are based on religious systems would be very difficult to
You actually have a different view. I mean, if I look at the civil procedure, civil law structure, it's much more precise. I mean, Italy, implementing the privacy directive, said passwords have to be this number of characters, change this number of times, and has this information has to be a longer length with a higher level of security. The difference between Frederick of Prussia and today is we have computers that can store and retain and apply those rules on our behalf almost as surrogate agents, and not necessarily rely on individuals to know the rules, which we had to do at the end of the 19th century in order to, quote, maintain civil order.
Okay.
darn cold not to have the doors in the substructure that we could open them up and build those when there's enough demand. That kind of anticipation can be done in the design with a level of comprehensiveness using technology that we don't have the human cultural capacity to absorb. And ultimately, the net and commerce are linked more closely than the net and culture.
Deb?
Yeah, it's interesting because I think I sort of I have a giant checklist in my head and a very vivid imagination. So those two factors give me every possible thing that could ever go wrong. And then I start knocking some of those off based on a risk assessment of what's the chance of it happening. And then I also put it through sort of a are you friend or foe category. And friends I would sort of draw broadly as anyone who's one of our member law schools, someone affiliated there. What is the chance of something really bad happening with those people, as opposed to someone that I find on Craigslist who's going to write some bit of code for me. And by the way, they're really hard to get hold of, also, sort of thing. So those folks are going to get far more of my paranoid drafting skills to play in. And so it is, again, leaning more toward the Prussian version of trying to dot every single possible letter there. But yeah, social norms definitely are playing in.
David?
So your key question is bad lawyering would lead to bad code. And I think the answer is yes. I think that lawyers have an opportunity to help shape technology the same way we in the past shaped architecture. And again, it is, I don't mean to harp on this concept of specifications, but that's what it comes down to. If the lawyer's job really is to make sure that agreements are expressed clearly. Our best role is in helping business people not negotiate and do battle, but take their plan to work together and get it all on the table and get it in writing in a way that's clear, that gets disagreements hashed out in advance and instead of in the middle of a project when it's too late and probably leads to a lawsuit. And get the four corners of the project clearly expressed. And drafting technical specifications and service level agreements is one of our key ways of doing that. We shy away from it because it feels new and uncomfortable. But if we do that, we're missing our opportunity to make sure the code says what it should say. If the HR department of a big company wants code developed for running its systems, and they're not really expert at expressing in the English language clearly what the system should do, and they assume, as is so often the case, that the vendor just intuitively gets it and understands what they're going to do, the lawyers have a tremendously valuable role to play of mediating between those two sides and getting them to agree on a written description of what the thing being created is, just as if they were building a bridge or anything along those lines, architecture, etc. And that is a job that we should not abdicate, because what we really remain experts at is using the English language to express complicated concepts in a way that brings people to agreement.
Thank you. And with that, I know the buses are going to be here in a minute, so a big round of applause for our panel.